How old is that technology? It's older than I am, practically. But following Kwan's lead in a case that we were involved in Georgia in the Third Circuit, Rayburg v. Hodges, this was a case of a whistleblower about corruption in the local government, and local authorities used a sham subpoena, an invalid subpoena, to get the content of his email. And the appeals court, following Kwan, said, well, you know, this email technology, it's so new. And we really don't want to make an unnecessary judgment on whether people have an expectation of privacy in their email. So with courts like this, it becomes all the more important what are your statutory protections. What protections has Congress given to you above and beyond the Fourth Amendment that protect your privacy? And Congress has passed a statute that does purport to protect your communications privacy. It's called the ECPA, the Electronic Communications Privacy Act of 1986, eons ago in internet time, and that's going to be a problem, as I'll explain. And in particular, the Stored Communications Act portion of the ECPA, which protects your stored communications and records about your communications activity. And it's not really that great. We appreciate the effort from Congress, but to very briefly summarize what it does, it creates rules, procedures that the government has to follow if it wants to get your communications or records about your communications from two different types of entities: remote computing services and electronic communications services. And those are pretty much what they sound like. A remote computing service is a service that you store your data with, or that you send your data to be processed for you. So online backup services, virtual storage lockers, that would be an RCS, while your email provider, your ISP, your IM provider, your phone company would all be ECSs. And what level of protection you get turns on which type of entity we're talking about. We'll start with RCS, which is in a really bad way. To the extent you're storing your data in the cloud, be it a storage locker, online backup, whatever, which I expect people with laptops are more likely to do. You want to be able to access your data anywhere. It's dead easy for the government to get that data. Rather than having to get a search warrant under this statute, they can get only a subpoena, which essentially a prosecutor on their own can write out a subpoena and serve it, or they have to get a much lesser, or they can get a court order that's much easier to get than a probable cause warrant. Instead, they just have to demonstrate that the information they're seeking is relevant to their criminal investigation. So basically, this isn't what they do when they have probable cause. This is how they get probable cause. This is before they have probable cause to know there's a crime being committed. It's while they're still trying to establish that. So it's very easy for the government to get the data that you store with a third-party remote computing service. And you don't get notified immediately. You're supposed to get notified, but there are very liberal rules for the government to delay that notice, based solely on a certification by a supervisory official that it would have an adverse effect on their investigation. And so they can get a 90-day delay of notice to you when they seize your files, which they can renew for as long as they think it would hurt their investigation. So very easy for the government to get that data. When it comes to your stored communications that are stored by your communications provider, the rules are much more protective, at least on their face. The government actually does have to get a warrant for the first 180 days. You're probably wondering, why does the law only protect, my stored emails that I store with Gmail for only 6 months? Well, remember, this law was written in 1986. This was back when we would dial into our BBS and pull down our email and delete it off the server. No one had enough storage was so expensive, no one was going to store your emails for a very long time. And if they even happened to store it for longer than 6 months, if you hadn't accessed it for 6 months, you'd presumably abandoned it and any privacy interest you have. So this is just one way in which this law is really archaic. Because there's this arbitrary cutoff at 6 months where you lose strong privacy protections and move to the RCS rules such that the government can get it with just a subpoena or an order based on relevance. Excuse me. So that sounds okay. You know, at least they have to get a warrant for, you know, your more recent stuff. So please do delete your stuff within 180 days if you can. But actually it's worse than that, because the government reads the statute in a really weird way. The statute protects communications that are in electronic storage, a defined term in the statute. And based on the particulars of that definition, the government doesn't think that definition applies to emails after you've opened them. And also doesn't apply to emails in your sent folder or your draft emails. So basically, under the government's view, under the primary federal electronic privacy statute that's supposed to protect you and encourage you to use these wonderful new services, the only thing that requires a warrant are the few emails in your inbox right now that you haven't looked at yet. This is a problem, suffice to say. And there is a great opinion in the Ninth Circuit, which includes this fine state here, disagreeing with the government and saying that even open mails are in electronic storage. But DOJ still disagrees. Its regular practice outside of the Ninth Circuit is to only use subpoenas or these lesser court orders to get all of your opened email and sent email and draft mail. And because of the Patriot Act, which allows for a nationwide service of this kind of process, they'll often use these orders or subpoenas to go after stuff stored in the Ninth Circuit using a court outside of the Ninth Circuit, something we've seen a number of times. Most recently in a case in Colorado that we participated in as friends of the court, where the government was trying to get this information, get some opened emails from Yahoo. And Yahoo was able to get their brief and the government's brief unsealed so that we could jump in and assist. And we got a great coalition of civil liberties groups and companies like Google to say, this reading of the law is boneheaded and this Ninth Circuit law contradicts it and you shouldn't do this. And the government was, well, okay, actually we don't need that anymore. We're just going to withdraw our application. So we couldn't get to the point where we actually got a decision saying, no, you can't do this. And this has actually happened to us a number of times, where federal magistrates who've been asked by the government to authorize these non-warrant seizures of email, we would get invited by those judges to brief them and give them our perspective on this boneheaded reading of the law. And twice now, 3 times counting this Yahoo case, as soon as we got involved, the government backed down. That's really flattering, but it doesn't move the ball at all. It actually keeps us from establishing the law in a good way. So it's because of this ridiculous open-unopened distinction, it's because of this ridiculous and arbitrary 180-day cutoff, and for a variety of other reasons, this area of law, and the Stored Communications Act in particular, needs to get updated by Congress for the 21st century, because it just isn't working anymore. And so we've been working very hard on a project called the Digital Due Process Coalition, in cooperation with the Center for Democracy and Technology and ACLU, and a broad swath of companies like Google and Microsoft and AT&T, an obvious enemy of ours in other contexts, where we've all gotten together and gone to Congress and say it's time to update the rules. And in particular, on this issue, it should be clear that a warrant is required if the government wants your data, whether it's from an electronic communication service provider or a remote computing service provider, whether you've opened it or not, whether it's in electronic storage or not. And there have been hearings on this, and we hope to have a bill sometime next year, because the problem is just getting worse, and the government is clearly not abandoning its, I'll say it once again, boneheaded reading of this area of the law. So in the meantime, if you can avoid storing stuff with a third party, please do avoid it. If you can pop your mail and delete stuff off the server as soon as you grab it, so that you don't have opened email sitting on a server that the government thinks it can get without a warrant, you should do that. Get a physical backup drive rather than using online backup if you can. Kurt is going to say a little bit of something about one other statutory protection for your data, or rather for the data of journalists.
Move up here for a second. So, I want to talk about one other statute, which is the Privacy Protection Act. This was a law passed in the wake of a 1978 Supreme Court decision, and that decision arose out of a situation in which the Stanford Daily, a newspaper at Stanford University, was subjected to a newsroom search. So they had written some articles and about an incident that the police were very interested in investigating, and they thought that they might find some useful information by searching the newsroom. Went in there and they took all the stuff, and this upset a lot of people because the court found that the First Amendment interests of journalists nor the Fourth Amendment interests of the journalists were sufficient to stop this search. And it created sort of the specter that the government could come in and raid a newsroom, not only looking for the evidence that the journalists might have based on their sources and such, but taking the material that was going to be for publication and essentially affect a restraint on future publication. So go seize all the materials about to be published and shut down the newspaper. So Congress, in sort of a rare bit of putting extra protections out there, passed the Privacy Protection Act, which makes it unlawful for the government to go and raid a journalist and seize the documentary material that is about to be published, or some of the excerpts from that material, even if that wasn't going to be published. And the law is written to protect a person reasonably believed to have a purpose to disseminate to the public a newspaper, book, broadcast, or other similar form of public communication. So this is a law from a long time ago where the modes of communication and publication were a little bit more limited than they are today. Now that the mode of communication includes a lot of different publications over the internet, this allows for a sort of a more expansive view of what would be protected by the Privacy Protection Act. There is an important exception to this, which is when it is the journalist themselves who are suspected of committing the crime. But the exception to that exception, stay with me on this. There's exceptions and exceptions to the exceptions. And the exception to the exception is if the crime the journalist is suspected of committing is the receipt of the information at issue or the publication of that issue. So they're trying to not create a sort of a catch-22 loophole where you can accuse someone of the crime of receiving the information and then get around this law. So in circumstances in which there is a search of a computer which holds documentary materials like notes or articles that are being prepared for publication, then definitely that is an additional issue that everyone should look into should that occur, and the EFF would be a wonderful organization to contact that if that happens to you. So I think that with that wraps up our lecturing portion of today's program, and we'll be happy to take questions that you may have.
Okay.
I've seen that it appears that the government has expanded what their definition of a border is within 100 miles of our national borders. I've seen something on the internet about that.
It has the government expanded its definition of what constitutes the border for these purposes.
And what I've seen is that I live in Michigan, and it's only about 200 miles wide.
Yeah.
The state of Michigan is basically considered a
The border search, so not to interrupt you, I just want to try to go. The border search exemption is about keeping the border safe as people cross the border, right? So if you live near the border, that's not where the exception applies. The exception is when you come in, and the question is how close to the border do they have to get you, and how long from the point that you enter do they have to be doing the search in order for that to be the thing that makes the border search exception apply. So this issue is actually not relevant to the way that the courts define the border search exception. Okay, that is a different thing that's court defined having to do with when the Fourth Amendment thing applies. This gentleman right here.
I know there's a somewhat open question about whether it contains testimonial or not. What about active assistance in looking at your laptop when you're dealing with the border officer?
Mm-hmm.
I have to explain that, but I have multiple accounts.
What about...
Stand back and listen to
Yeah. What about do you actually helping border search agents or border agents when they're doing searches of your computers as you come